Welcome back. We're in the middle of our discussion of the amendments to the Constitution. You hear a lot about the original intent and the framers, but just think for a moment about how significant the amendments are to your life, to our collective life. Think about the Bill of Rights, freedom of speech and freedom of the press, free exercise of religion, right to counsel, and so on. Those rights are parts of the amendments to the Constitution, not the original document. And you might say, well, they're still part of that founding moment, that founding era. True enough, although even then, note that the very phrase, Bill of Rights, was not the phrase that appears in the document itself or that was common at the founding period, at least in official references to these early amendments in places like Supreme Court cases. The Supreme Court doesn't start referring to these early amendments as the Bill of Rights until after the Civil War and because of the Civil War. Because during the Civil War and the amendments, the next generation of amendments, people talked a lot about the Bill of Rights and described the early amendments as a Bill of Rights. And way more important than merely describing them as a Bill of Rights, the framers of the 14th Amendment, after the Civil War, a much later generation of Americans, insisted that that Bill of Rights apply against state and local governments, what lawyers and judges call incorporation of the Bill of Rights against the states. Remember, the First Amendment says, Congress shall make no law abridging free speech and free press. But what happens when states try to shut down free political discourse about, for example, slavery? That's not a hypothetical. That actually happened in America in the antebellum period. States tried to shut down political discussion, made it a crime to be anti-slavery, a member of the Republican Party, put preachers in the pulpit, in prison, for preaching against slavery. So not just free speech and free press, but free exercise was threatened by this regime. When you think today about the most important Bill of Rights cases that come to your mind, I suspect you're actually, strictly speaking, not thinking about the original Bill of Rights. You're probably thinking about cases involving state and local governments. You're thinking about New York Times versus Sullivan, or Miranda versus Arizona, or Lawrence versus Texas, Griswold versus Connecticut. None of those, strictly speaking, is a Bill of Rights case. Every one of those is a 14th Amendment case, a case in which a state was claimed to have abridged a fundamental freedom of Americans, a state or locality. Now, from the beginning, at the founding, James Madison actually worried that states would misbehave when he actually proposed a Bill of Rights or early amendments to the Constitution in the first Congress. He had an amendment that said no state shall, but he didn't get the votes for it because in the wake of the American Revolution, with a lot of states' rights, anti-federalist sentiment, very powerful at that time, a lot of Americans were fearful of the central government and thought they could trust state governments. Remember, the American Revolution was fought by local governments against an imperial center, and the Bill of Rights reflects that American revolutionary anti-federalist states' rights sentiment. Remember, it begins, Congress shall make no law, and it ends with the 10th Amendment reaffirming the idea of enumerated powers of the federal government and reserved powers of the states. So the original Bill of Rights, anti-federalist to some extent, protecting rights only against the federal government. Madison wanted more, but he couldn't get it at the founding. But the Reconstruction generation did get it. John Bingham, the main draftsperson of the key section of the 14th Amendment, was able to accomplish in the 1860s what James Madison, an earlier congressperson, was unable to accomplish in the 1790s. So the amendments loom so large for us. If you think the Bill of Rights is important, then I suspect that what you really think is important is how the Bill of Rights has come to apply against the states. Because, in fact, before the Civil War, even though these early amendments were on the books, they weren't vigorously enforced by courts. Congress passes a sedition law, and courts make it a crime to criticize the federal government. It says, Congress shall make no law abridging free speech, Congress made freedom of the press. Congress made such a law, and courts enforced it. Supreme Court justices put men in prison for criticizing the government. And they, so the Bill of Rights didn't mean so much on the ground until the only Bill of Rights case that the Supreme Court, where the Supreme Court before the Civil War enforces the Bill of Rights against the federal government, is the preposterous ruling in Dred Scott in 1857 that when Congress prohibits slavery in the territories, when it basically says, don't bring your slaves here. If you do, you'll lose them. Keep them out of the territories. You can keep them where they are, but don't bring them into these territories. These territories are free soil. Dred Scott said that law violated the Bill of Rights. That law was unconstitutional. Why? Because it violated, it was a deprivation of property without due process of law, said the Taney Court. But that's preposterous, because the law was passed by Congress and enforced by judges and juries. That is due process of law. That's fair procedure. But the Fifth Amendment says, and the Fifth Amendment surely says due process, and it says the federal government can't violate due process. That phrase comes from England. And England has always had the rule that you can't bring slaves onto English soil, that if you do, you'd forfeit them. That's the land of due process. Due process was always understood as consistent with prohibiting slavery. But that's the only enforcement of the Bill of Rights against Congress in the antebellum period, the pre-Civil War period. The Bill of Rights today means a lot. It's in a part of every American's daily life and part of your consciousness because of cases, basically, much later cases, applying the Bill of Rights against state and local governments. And that's because of the 14th Amendment. A later generation, or put differently, today we believe passionately in equality, equality of persons, of black and white, male and female, Jew and Gentile. The framers' Constitution did not emphatically embed that equality idea. The Declaration of Independence had lofty language, drafted by a slaveholder, interpreted differently by different people, but not quite binding law. The 14th Amendment puts that word equal in the Constitution in connection with individual equality, equality of all persons. The original Constitution talked about equality of states voting in the Senate. Each state gets an equal number of votes, namely 2 in the Senate, but had nothing about equality of persons. That's a 14th Amendment textual commitment, not a founding era textual commitment. It's all about the amendments. Look who's president today. Barack Obama. Barack Obama doesn't get elected president under the founders' rules, which were pro-slavery in some very important ways, advantaged the slaveholding South, had no guarantee whatsoever that people would be allowed to vote equally regardless of race, color, or previous condition of servitude. The framers said nothing about equality of voting rights regardless of race. The Reconstruction generation, the amenders, added that 15th Amendment. Without that amendment, I think it's just unimaginable that someone like Barack Obama could be president. There's something like the Voting Rights Act of 1965, which we'll talk about in later lectures, could ever pass. So George Washington is absolutely central to our constitutional vision. We'll talk a lot about Washington's particular constitutional vision in later lectures. In fact, there will be 2 lectures devoted just to Washington's vision, and he's on the $1 bill, and rightly so. He embodies national security and geostrategy, and he is pro-slavery, although in that he's a slaveholder and he dies a slaveholder, but he, at the end of his life, is trying to move away from slavery, and that is one of many, many things to be said in favor of the greatness of George Washington. But Washington will give way to Jackson, another general who can beat the British, embodying national security, but now in a much more aggressively pro-slavery way. Washington wanted to end slavery at the end of his life. Jackson never said anything like that. much more pro-slavery, puts Roger Taney on the court. And Jackson is the most important figure in antebellum America. And he's going to give way eventually, and that system fails, to Abe Lincoln. So you got the $1 bill, George Washington, you got the $20 bill, Andrew Jackson, but the $5 bill, Abe Lincoln, we today live way more in Lincoln's house than in either Washington or Jackson's, or Thomas Jefferson's, James Madison's for that matter. We live in a house that was divided against itself because of slavery, that fell because of slavery, call that the Civil War, that got rebuilt, that house, reconstructed, if you will, by Abraham Lincoln's generation. So we live, I would argue, far more in Lincoln's Constitution than we have understood. That's the generation that rebuilt the Bill of Rights, in effect, and applied it against the states and promised equality, civil equality for all, racial equality, even in the franchise. That's the modern world that we live in, and it's a world of the amenders. So founding fathers, yes, we spent a lot of time talking about their vision. That's what all the early lectures were about, their vision. But I don't want you to forget that our Constitution is an intergenerational project, and you have to take seriously the amendments as well as the original founding vision. Now, in that spirit, in the remainder of this lecture and in the next one, I'm going to talk about the next great wave of amendments. We've talked about the Bill of Rights. We've talked, and the 11th and 12th Amendments at the founding. We've talked about 13, 14, and 15 after the Civil War. Now let's talk about the next cluster of amendments, especially the 16th, 17th, and 19th Amendments. Now, you may have noticed that the amendments come in these generational spurts or clusters. There's the founding era, generating the Declaration of Independence and the original Constitution and the first 10 amendments and 11 and 12, and then nothing for more than a half century, nothing after the 12th Amendment early in Jefferson's administration, nothing for a half century, then this cataclysm of Civil War and Reconstruction generating 13, 14, and 15, so the next generational spurt, then nothing again for another half century, basically. And then another generational spurt, 16, 17, and 19, most importantly. And I'm going to spend the rest of this lecture just making the case that, again, our modern world owes a great deal to the amendments, that the 16th, 17th, and 19th Amendments are huge features of your constitutional world today. The founders, a lot of founders said, well, the federal government won't do very much. Most of the things will be done by states. And today the federal government does lots. And some people, some of my friends in the Tea Party think that that's somehow improper, illegitimate, and not constitutional. And I say to my friends in the Tea Party, well, take another look, because it's not, the Constitution isn't just the founding. It's a series of amendments, and the amendments are nationalizing amendments after the Bill of Rights. Remember, yes, the Bill of Rights begins, Congress shall make no law of a certain sort, and ends with the 10th Amendment. But the 13th, 14th, and 15th Amendments all end with the words, Congress shall have power, each one of them reflecting the nationalism of the Civil War as opposed to the localism of the Revolutionary War. So these amendments after the Civil War codify that nationalism. Congress shall have power, 13th Amendment, Section 2. Congress shall have power, 14th Amendment, Section 5. Congress shall have power, 15th Amendment, Section 2. So those amendments reflect enhanced federal power, and so do amendments 16, 17, and 19. Another thing that's happened in American history is wars, the Civil War, World War I. Wars tend to enhance the powers of the federal government vis-a-vis the states, and that's going to be a trend. Remember, in the middle of the Civil War, Lincoln is trying to unify America, reunify it, not just north and south, but east and west through a transcontinental railroad. At the founding, the framers said things that are genuinely interstate, transactions that involve more than one state, that really spill over across state lines, those things the federal government can regulate, interstate commerce. But the reality at the founding is most stuff isn't interstate. Most people live and die in a 50-mile radius. You don't have a transcontinental railroad or jet travel. So much of the economy genuinely is local at the founding. Before refrigeration, you have cows everywhere because you need fresh milk. With the advent of refrigeration, you need cows just in a few places, California, Vermont, Wisconsin, a few more, and we can all drink from those cows because we've got transportation and refrigeration and communication technology, and Lincoln is a huge part of that, like with the Transcontinental Railroad. So one of the reasons we have more federal power today is that our world is genuinely more interstate and international, more connected than it was at the founding. And that's just a fact about the world that's changed. The framers said, if it's interstate, if it's international, the federal government can do it. And just a lot more stuff today is interstate and international in a world of the internet and supersonic travel and the GATT and international trade. So a lot more of the world is genuinely international. That's a fact about the world. But also the Constitution has been amended to expand federal power, not just 13, 14, and 15 on matters of race and civil rights, that the federal government will take the lead in championing voting rights, the 15th Amendment, civil rights, the 14th Amendment, and racial rights generally, all three amendments. It's not just, and human rights, not just that the federal government will have a special competence here that it didn't have before, but 16, 17, and 19 add additional federal powers and competences. At the founding, what's the federal government basically supposed to do? Interstate affairs, Western land, and foreign affairs. And raise money for. So if it's a revenue measure, the federal government can pretty much do it. If it regulates an interstate problem, the federal government that spills over across state lines, the federal government can pretty much do it. If it's a national security matter, the federal government can pretty much do it. If it's a foreign affairs matter, that's sort of the founding vision. Reconstruction adds if it's a civil rights matter, a human rights matter, a voting rights matter, the federal government can do it. Now, the 16th, 17th, and 19th Amendments are going to continue to broaden the scope of federal power. The 16th Amendment is going to affirm, and does, and it's adopted at the beginning of the 20th century, the power of the federal government to impose an income tax on individuals. The 17th Amendment is going to make senators directly elected by the people of each state rather than the legislature of each state. And the 19th Amendment provides for women voting equally with men. Now, my claim is you put 16 plus 17 plus 19 together, and you get the New Deal, the Great Society, Obamacare. Here's how. And when you add all that to the founding, here's how. The 16th Amendment is going to be about a power of the federal government to use its taxing power to accomplish national redistributive projects. We'll talk more about this in the next lecture, but the 16th Amendment was very much designed by people who called themselves progressives, who believed in a progressive income tax that would redistribute, that would take more, redistribute economic resources, take more from the wealthy. And you can more easily do that at the national level than at the state level, because if a state tries to do that, the rich people move out and the poor people move in. But if the federal government tries to do that, it has a lot more ability to pursue national redistributive projects. What does the 17th Amendment do? The 17th Amendment frees U.S. senators from dependence on state legislators. They're going to be more free to pursue all sorts of national projects, precisely because they're freed from dependence on state legislatures. Even if they had the power to do something under the founding regime, they might have hesitated to do it because state legislatures wouldn't like that. Well, now it doesn't matter what state legislators like. It matters what the voters want. So a modern world in which lots of senators become presidents, well, that's in part because senators are now directly elected populist politicians. That's the 17th Amendment world. The 19th Amendment, women are going to vote. Eventually, we come to see that women tend, on average, or at least have for much of the last century, to vote more for social welfare measures, for, if you're a critic of it, the nanny state, if you will. We call that in part, the gender gap. And today, more women than men are voting. And so you add the 16th Amendment, national redistributive power in the federal government, and the 17th Amendment, a Senate much more willing to vote for big federal projects, and the 19th Amendment, women voting and women voting for Social Security and daycare and education, maybe because women historically have taken care of others in their elderly parents or dependent children, maybe because women then are particularly attentive to those vulnerable members of society, maybe for other reasons. I frankly don't know why, but the data does suggest that women have, in recent eras, voted more for some of this social welfare legislation than have men. And that's a constitutional development. It's an amendment development. 16 plus 17 plus 19 is very quickly going to give you Franklin and Eleanor, 19th Amendment, and with a New Deal, and Bill and Hillary, Barack and Michelle. It's going to give you, in short, 16 plus 17 plus 19, the New Deal, the Great Society, and Obamacare. And these, I claim, are fully constitutional, not just because of the founding vision, but because the founding vision has been supplemented by the Reconstruction vision, by the Progressive era vision. In my next lecture, we're going to walk through these amendments in a little more detail, with particular attention to the 16th Amendment, the Income Tax Amendment, the 17th Amendment, the direct election of senators, and the 19th Amendment, maybe the most dramatic of all, the Women's Suffrage Amendment. So stay tuned. Welcome back. We're in the middle of our discussion of the Progressive era amendments, and we're going to focus in particular on the 16th, 17th, and 19th Amendments. The 16th Amendment, the Income Tax Amendment, reaffirms the power of the federal government to impose a tax on income. And I say reaffirms because, in my view, the federal government always had this power. Remember, the Constitution is basically a pro-tax revolution enacted shortly after the anti-tax revolution of 1776. The Constitution is all about taxation with representation. The Declaration of Independence and the American colonies opposed, it said the Declaration of Independence in effect said, and the colonists at the Revolution said, no taxation without representation. And the Constitution, Article 1, Section 8, is all about taxation with representation. And we need taxation for various purposes, most dramatically national defense. And the longest section of the longest article is Article 1, and the longest section is Section 8. And Section 8 begins by saying Congress shall have power to basically tax you up and down and sideways, impose taxes, duties, imposts, and excises. How many ways can they basically say that you're going to be taxed, but don't worry, or at least there's a reason why, maybe you should worry, but there's a reason why we need taxation for national security, and it will be legitimate because Congress will be representative. And in my view, there was nothing about a federal income tax that was distinctively problematic. And Abraham Lincoln thought the same thing. And during the Civil War, he signs his name to a law that imposes an income tax, and it's a progressive income tax. It taxes people who make who have more income at a higher rate, and it exempts people who make below a certain amount. Those are the two basic features of a progressive income tax. A progressive income tax basically takes proportionately more from the people who are making more money by exempting people below a certain amount and by having higher tax rates proportionately for people who are higher income earners. So Lincoln signs an income tax statute in the middle of the Civil War, and it's upheld by courts. Many states had income taxes, all of which generally were progressive. But the Supreme Court at the end of the 19th century did an about-face and said, income taxes are unconstitutional. And that's in part because the party of Lincoln, which begins as an anti-slavery party, eventually, because of, it becomes the dominant party. The Democrats have discredited themselves because of slavery and secession. Lincoln's dominant political party attracts a lot of money and other things, so it morphs from a kind of an anti-slavery party to a corporate party. The party of Lincoln becomes the party of Grant, becomes the party of McKinley. And in that era, the Supreme Court, by a 5-4 vote over an emphatic dissent by John Marshall Harlan, the first John Marshall Harlan, the same guy who dissents in the Plessy versus Ferguson case, but over his emphatic dissent, he says this ruling is going to be a disaster for the country, but over his dissent, 5 justices proclaim an income tax unconstitutional because it's, quote, in their view, a direct tax which requires state apportionment. I'm not going to go into all the details except to say that I don't buy it. A lot of constitutional scholars who have studied the matter don't buy it. A lot of tax experts who have studied the matter carefully don't buy it. The direct tax language of the Constitution was very much bound up with all sorts of compromises about slavery. They were ways of camouflaging some of the pro-slavery aspects of the Constitution by linking the idea of apportionment, representation, with taxation, but direct taxation. As I said, I'm not going to go into all the details except to say that I don't think an income tax is an improper direct tax within the meaning of the Constitution. A direct tax is something that you simply can't avoid at all. A head tax, putting a tax of $10 on every person. Well, you just can't avoid that, short of death. That's a direct tax. It's also called a capitation. And one of the reasons the framers tried to limit direct taxes is they didn't want early Congresses to be able to, in effect, prevent the importation of slaves from abroad by taxing slave importation or taxing slaves themselves. So there were various pro-slavery compromises built into some of the language about direct tax, but even at the founding, I think it meant something very narrow. You can avoid an income tax, just don't make income. Live off of your savings, do other things. So an income tax is not a direct tax. Maybe land taxes of a certain sort were also seen as direct taxes. Direct taxes on pieces of real property. But an income tax, I think, at the founding was understood as a permissibly transactional indirect tax that was perfectly okay. And so thought Abraham Lincoln and his generation, and the court originally upheld it, but then they invalidated it. And the American people basically rose up against the Supreme Court. Only 4 times in American history have the American people responded to a Supreme Court decision by overturning it by amendment. The 11th Amendment, when the judiciary early on went too far in expanding its own powers, that in a case called Chisholm versus Georgia, and that generated the 11th Amendment. Dred Scott went too far in a whole bunch of ways, and the 14th Amendment repudiated the Dred Scott case. The Pollock case, this income tax case, is repudiated by the Income Tax Amendment, the 16th Amendment, and then there's going to be one more later in our story, so stay tuned on that one. Now, members of both parties supported the Income Tax Amendment. Teddy Roosevelt and William Howard Taft for the Republicans. Woodrow the Democratic Party was also on board. So amendments succeed when both parties are in favor of them, and that's what happens with the 16th Amendment, which, as I said in my earlier lecture, my previous lecture, sort of laid the foundation in some very important ways for the modern redistributive estate. The income taxes that we've had have always, at least in theory, been progressive redistributive income taxes. In practice, one can raise questions. The 17th Amendment, also adopted in the 19-teens, as was the Income Tax Amendment, the early 19-teens, the Income Tax Amendment, provides for the direct election of senators. And you might wonder, why would existing senators ever go for that? Because remember, no amendment can pass unless 2/3 of the House and 2/3 of the Senate and 3/4 of the states say yes. So why would existing senators, who are basically picked by state legislatures, ever vote to change the rules by which senators are picked? And part of the answer is by the time the 17th Amendment comes along, a bunch of senators are already kind of directly elected. There have been improvisations in the founder system. These improvisations begin as early as the 1850s with the famous Lincoln-Douglas debates in the wake of the Dred Scott case. In 1858, Abe Lincoln wants to be U.S. Senator from Illinois, and Stephen Douglas, who's the current U.S. Senator, wants to be re-elected. And legally, strictly speaking, the senator's going to be picked by the Illinois state legislature. But what Lincoln and Douglas do, what the political parties do, the political parties basically say, before the state legislative election, the Democrats say, we're going to nominate Stephen Douglas, and the Republicans say, we're for Abe Lincoln for Senate, and they announce that before the state legislative election. Now the state legislative election kind of becomes a referendum of sorts on whether you're a Lincoln man or a Douglas man. If you're a Lincoln man, vote Republican for state legislature. If you're a Douglas man, vote Democrat for state legislature. Now, it's not perfect. It's not a perfect referendum because there's some malapportionment and gerrymandering, and not all districts are open in the election, and there might be other issues that you care about other than Lincoln versus Douglas. So it's not perfect, but the election in 1858 for a state legislature was kind of rough referendum on whether you preferred Lincoln or Douglas. And in fact, Lincoln's supporters cast slightly more votes than Douglas's supporters, but not quite enough to swing the election in his favor. Later generations of Americans will sort of further improvise toward a direct election system. In states that have basically where one party is dominant, the key becomes to election becomes winning the party nomination, and if the state uses a primary system to pick its a nominee, well, then the primary becomes, in effect, the direct election. And a bunch of states, basically, especially in the South, were one-party states. The Democratic Party was the dominant party in some southern states, there were other one-party states in the Midwest. So primaries were a kind of direct election. Oregon improvised a different system. Oregon basically said, when you vote for Congress, for a U.S. Senator, for a member of the House of Representatives, for state legislature, when you vote, we're going to put on the ballot a non-binding question. The non-binding question is, whom do you prefer for the U.S. Senate? Okay, and there were different iterations of it. The first version, like, whom do you prefer? And then, we're going to actually have a second question. State legislators have to either promise to support the winner of the beauty contest. The beauty contest is who do you want for U.S. Senator. So you either, if you're running for state legislature, your name appears on the ballot, and whether you're Republican or Democrat, and whether you've taken the pledge. I pledge to support the beauty contest winner. So if you pledge to support the beauty contest winner, even if you're a Democrat, if the Republican wins the beauty contest, you're promising to vote for the Republican for U.S. Senate. So second version is your name and whether you've taken the pledge, and your party and whether you've taken the pledge. And an earlier and later version is you're actually required to honor your pledge. Now, what exactly that means, is that constitutional? But in any event, by the time the 17th Amendment comes along, a bunch of senators are already kind of directly elected through some version of the Oregon plan or through the primary system in one-party states. And the 17th Amendment's adoption is a great democratizing moment that will actually have reverberations later on. It's going to, for example, help make it easier for the U.S. Supreme Court much later to insist on one person, one vote for state legislative elections. Why? Because when state legislatures picked U.S. senators, remember, state legislatures might be kind of malapportioned, and that malapportionment would be the basis for the U.S. senators' election and re-election. So U.S. senators would have a stake in state legislative malapportionment before the 17th Amendment. And they might make it hard for justices to invalidate state legislative malapportionment because, remember, justices have to be confirmed by the Senate. But with the 17th Amendment, now U.S. senators are going to be elected one person, one vote statewide. They don't have a particular stake in state legislative malapportionment anymore. Think about how the 17th Amendment has kind of transformed the presidency. Before the 17th Amendment, members of the House were directly elected. Yes, they were more numerous, they were less prestigious. Senators were smaller, more elite, more prestigious, but they weren't directly elected. So maybe a person from the House could say, you know, I'm more of a populist politician than a person from the Senate. Well, after the 17th Amendment, senators become every bit as populist as House members, but elected statewide for 6-year terms, a much more select body. So no member of the, before the 17th Amendment, various people went from the House of Representatives to the presidency without having their ticket punched in the Senate. After the 17th Amendment, we haven't had any of those types, who include people like James Madison, for example, James K. Polk. But not since the 17th Amendment has a mere House member, a non-senator, won the presidency, like Newt Gingrich or Dick Gephardt, something like that. 17th Amendment has even changed how we think about the cabinet. At the founding, your state legislature sends you to the Senate, but they might prefer that you be in the cabinet. You can deliver all sorts of goodies to the state, so here's what they tell you. Go into the cabinet, we'll hold your seat, and when you're done with your cabinet service, you can go back, we'll give you your Senate seat back. Cabinet sandwiches, Senate to cabinet, back to Senate. There were a bunch of those before the 17th Amendment. That's not an easy deal. You can strike with the electorate at large. It doesn't quite work. So before the 17th Amendment, lots of cabinet sandwiches. After the 17th Amendment, no cabinet sandwiches. People leave the Senate to go into the cabinet, but they don't go back to the Senate. Lloyd Benson, Hillary Clinton, John Kerry, and others. They might leave the Senate to go to the cabinet, but they don't count on going back to the Senate anymore. So the 17th Amendment has actually kind of changed all sorts of other aspects of government. Senators used to be much more commonly picked as Supreme Court justices. Since this, in recent decades, not so much. Maybe that's because now U.S. senators have to be much more populist politicians than before, when they were sort of more elite statesmen. Maybe their earlier job description was a little closer to what a Supreme Court justice does, and their new job description is rather different. You have to be a populist politician, and maybe that's in slight tension with the kind of persona and personality that makes for the best Supreme Court justice. So the direct election of senators has had some all sorts of interesting indirect effects, if you will, over the cabinet, over presidential elections, and over the scope of national power, as I argued earlier, that senators are going to be much more willing to vote for nationalist projects. You're going to need a lot of money, maybe, to run for the Senate, and so people who thought the Senate wasn't going to be a millionaires club anymore if we have direct election, not so sure that they turned out to be right, but maybe the money is getting spread around in democratic campaigns rather than in bribes into the pockets of state lawmakers, for example, old-style state legislators. So the 17th Amendment has actually reconfigured our system, I think, in all sorts of interesting ways. But by far, the most important amendment, it seems to me, of the progressive era is the 19th Amendment, the Women's Suffrage Amendment. It's, in effect, a doubling of the franchise. So now, by the numbers, maybe the most democratic event in all of American history. And now let's take a step back and try to figure out how that happened. Because here's the real interesting thing. Before women get the vote, only men are voting, and only men are going to therefore be voting on whether women vote. So how do women ever sort of bootstrap themselves into the vote? Because they can't vote themselves the vote. They have to rely on men to vote first. So how does that ever happen? And the answer is gradually. It takes 50 years for women basically to get the vote, from the Civil War era, when black men get the vote with the 15th Amendment and women are shut out and they're very disappointed. It takes 50 years from that for them to finally prevail, the 19th Amendment, 1920. And as with many constitutional reforms, this one begins first in the states. Federalism is an important part of our story here. national security is also going to come into the story. So it's going to be a story of democracy and its relationship to federalism and national security. Here's the federalism story. Remember the great American project of populating the West, this epic story of taking these, this nearly virgin soil and creating civilized structures which will eventually, and populating them and eventually admitting these regimes on equal footing with the older states. It's an amazing project, and part of that, in places like Wyoming, getting people to come to Wyoming, and in particular, getting women to come to Wyoming. Because in 1870, Wyoming basically, which is a territory, has, I think, 5 white men for every white woman. And they're desperate. They want women to come. And they're so desperate that they actually start saying, well, maybe we should actually listen to what women say. Women say they want to vote. So we're going to let them vote. If they come to Wyoming, we'll let them vote. And, hey, they say they want equal pay for equal work. We'll promise equal pay, too. So Wyoming first promises this, the Wyoming territory. And Wyoming and Utah and Idaho and Colorado are the first states to promise women the vote. And the interesting thing is these are the states where there aren't very many women. And in a way, when you step back, it makes sense, because if men and women in a jurisdiction are 50-50, and you give women the vote, and it turns out to be a mistake, because remember, the rest of the world isn't doing this yet, so you experiment. You give women the vote, and if it's 50-50, then you can't undo it. But if you outnumber them 5-1, you give them the vote, it's a mistake, maybe you can take it back. Places where the men outnumber the women are also places where the men are most desperate to get women to come emigrate, and so supply and demand meets in a good place for women's suffrage in those jurisdictions. So it's a federalism story to some degree. Men, the irony is the place where women get the vote first are the place where there are the fewest women. And that's not just true, Wyoming. And that's not just true in America, but in the world. The state where, the country that first gives women the vote is New Zealand, which is kind of the Wyoming of the British Empire, where men outnumber women. In Australia, which also has kind of territories, a federal system, the places where women are fewest, Western Australia, the kind of Wyoming of Australia, gives women the vote earlier. So this is a story that it's true more internationally, but then here's the second part of it. So some states experiment. Federalism, laboratories of experimentation. And states are innovating here just as states first had bills of rights and written constitutions and 3 branches of government and bicameral legislatures, and states are getting rid of slavery first. And so states are leading the way on all sorts of things. States are putting constitutions to special votes first. So here's a few states are giving women the vote, and the sky does not fall. So the other states start to follow suit eventually. I'm saying, well, if you're going to come all the way across the plains and over the mountains, why stop in Wyoming? Come all the way to California. Come to Oregon. Come to Washington. So other states start following suit at the beginning of the 20th century. By 1909, only 4 states with only 2% of America's women, Colorado, Utah, Idaho, and Wyoming. 1909, only 4 states. But by 1915-16, a whole bunch of states have begun to join the bandwagon. And now, if you want to run for president, you're a U.S. senator, you have to be in favor of women's suffrage. Because if you're not in favor of women's suffrage, you're conceding all those women's suffrage states. So one senator from Ohio, he's opposed to women's suffrage. His name is Atlee Pomerene, and you've never heard of him. The other Ohio senator who's in favor of women's suffrage, his name is Warren G. Harding, and he's going to get himself elected president on those women's votes. So once you see it start happening in a bunch of other states, you say, if you're a national politician who wants to be president, and that means lots of folks in the Senate, hey, I want to be in favor of that. And once you see different states voting, taking votes on women's suffrage, and women's suffrage losing, let's say, 70-30 in the first vote, but the women keep pushing, and then the next time women's suffrage loses, because remember, only the men are voting for it, on it, so it loses 70-30. Then the next time, 3 years later, they get on the ballot again in the state, and it loses 60-40. And then they get on the ballot yet again, 3 years later, because they're persistent, these women suffragettes. And then it only loses 55-45, and now you think, eventually they're going to win. And if they win, do I want to be the last politician standing in the schoolhouse door resisting women's suffrage? Because as soon as they win, they're going to vote me out of office. So I have to pay attention not just to the men who voted for me, but the women whom I might need for my re-election. And so you go from only 2% of America's women voting in 1909 to 100% in 1920. Once male politicians think that women are going to get the vote, it becomes almost a self-fulfilling prophecy. Then everyone kind of clambers on the bandwagon, wants to jump aboard it so that they're not on the wrong side of politics and history. So that's a federalism story. It's a story about political incentives. It's also, though, the story of women's suffrage, and it's a story of women being very emphatic and working tirelessly again and again and again to get this. Women like Elizabeth Cady Stanton and Susan B. Anthony and their successors. But it's also a story of national security, because what else is happening in this period? America is at war, World War I, and Woodrow Wilson initially opposes women's suffrage. He's a Southerner. Actually, he pretends he's a New Jersey person, but he's born in Staunton, Virginia. He grew up in Georgia. People in Georgia don't like the 15th Amendment, which guaranteed equal voting rights for blacks, so they don't want a 19th Amendment that's going to basically be the same thing except for sex, more federal intrusion into state voting regimes. Southerners don't like that. Wilson is a Democrat. He's a Southerner. That's the base of the Democrat Party. He's inheriting still Thomas Jefferson's party, so initially he's not in favor of it. But then the women start shaming him. They chaining themselves to the White House gate and demanding rights for women, saying, you're in a war, and you say it's a war for democracy, and yet you don't let your own women vote. And we're part of the war efforts. Yes, we're not on the battlefield, but we are providing the economic support that's helping the war effort. And so Wilson switches. And here's one of the other reasons that he switches. He believes that this war is about something, and eventually he wants it to be a war to end all wars. He wants to have a League of Nations that will emerge after the war, a League of Nations in which the United States is going to have to be involved so these European countries don't kill each other again, and suck America in. So the United States is going to have to play a central role in the League of Nations as sort of the arbiter of old world disputes. And he, as president, Woodrow Wilson, will be the leader of the free world. That's a new now job description of the president, not just commander-in-chief and veto-in-chief and appointer-in-chief, but leader of the free world. And he's imagining that for himself, and he's imagining that vision for the United States. But the United States will not be able to lead a League of Nations, which is going to be based on ideas and morals and not just who has the most military might. The United States will not have that moral leadership, and Wilson very much thinks of himself in terms of being a moral leader, won't have that credibility if we don't let, here in America, our women vote, especially because around the world, other societies are beginning to let their women vote. So Woodrow Wilson comes personally to the Senate of the United States dramatically. Since Jefferson, presidents basically had only sent messages to Congress. They didn't appear personally before Congress. But Wilson shatters that precedent and it goes and appears personally before the Congress for various things. And one of them is an appeal to Congress to get them to support a woman's suffrage amendment as a war measure. And he's explicit that this is as war. And now both parties eventually join on board, the Republicans and the Democrats, because if women's suffrage is going to happen, you don't want the other party to get the credit without your party getting the credit too. And Republicans say, well, we're the party of Lincoln, and we gave you the 15th Amendment, so now we're going to do it again with the 19th. And the Democrats say, we're the party of Woodrow Wilson, and he's in favor of it, so we are too. And you get the 19th Amendment, and the world will not be the same. Women's suffrage, I think, transforms the nature of of American politics. Today, more women vote than men. If women all voted for the same candidate, they could basically decide every election in the country. And if the men are close to evenly divided, the women decide. That's because of the transformative 19th Amendment. And I'm going to come back to that in, well, let me just tell you that that's what this depiction is all about. Women crusading for women's votes, marching in New York City. I think this is in 1912 or so. I believe they're marching down Broadway. I'm going to come back to this at the very end. There are other amendments of the progressive era. The 18th Amendment gives you prohibition, and the 21st Amendment takes it away, sort of undoes it. There's an amendment about having the presidential term begin in January rather than January 20th after the November election rather than in March. I'm going to say a little bit more about that amendment in my next pair of lectures, because that amendment is designed to reduce the lame duck period. Someone gets elected in November, but they have to wait all the way till January before taking office. It turns out, and before the 20th Amendment, they had to wait all the way till March. It turns out there's a way of having the person who won the election, let's say Romney had won the election against Obama, having that person take office not in January, but the day after the election. It turns out there's a way to do that, and that has to do with a later amendment, a later 20th century amendment that we're going to talk about in the next pair of lectures, the 25th Amendment. So we're going to talk about that in the next set of lectures, and we're also going to talk about another generation of Americans that takes to the streets. The women are taking to the streets to right a great historical wrong and injustice, that they've been excluded from the franchise, and that's not right. And they take to the streets in the 19-teens, and they prevail. 50 years later, another half century later, a new generation will arise, another generational spurt of amendments, and this generation will once again take to the streets to right some great historic injustices and wrongs. And that's the story that we're going to tell, among others, in the next pair of lectures. So stay tuned. Welcome back. We've now reached our final chapter, quite literally, in the story of the written Constitution. I say quite literally because, as you'll recall, we're walking through the written Constitution in textual order, and in the process we're also tracking a book that I did in 2005 called America's Constitution, a Biography. And that book tracks the flow of the text, which is in turn chronologically laid out. We started with the founding era, the original Constitution, followed very quickly by the first 10 amendments, the so-called Bill of Rights, a judiciary-limiting 11th Amendment, and a pro-populist, pro-partisan presidency, pro-democracy, but alas also pro-slavery 12th Amendment, codifying kind of the Jeffersonian vision of the presidency, and that brought the founding era to a close, the original Constitution and the first 12 amendments. Then we moved forward in time, and after the Civil War, we encountered the 13th, 14th, and 15th Amendments, ending slavery and guaranteeing civil and eventually political equality to African Americans. More recently, we flashed forward yet again and focused on the amendments of the progressive era, the beginning of the 20th century. We focused particular attention on the 16th, 17th, and 19th amendments from that era, income tax, direct election of senators, and women's suffrage. Today and in the next lecture, we're going to talk about the more modern amendments, the late 20th century amendments. And as I said, that's the last chapter of the book, America's Constitution, a Biography. But before we talk about the late 20th century amendments, you might have thought that I gave short shrift to the 18th and the 21st amendments from the early 20th century, the 18th enacting prohibition and the 21st repealing it. And if you thought that, you were right. I did kind of breeze by those because the 21st basically, in effect, undoes the 18th. I can't cover everything in exquisite detail in these lectures. If you do want more background on those amendments or on virtually anything else that we discuss in this online course, the book has lots more detail on that. But I thought I should say just a word or two about the 18th and the 21st before moving forward. The 18th Amendment was part of the progressive era, and those who supported Prohibition saw it as consistent with, many of those who supported it saw it as very consistent with the other reforms of the era, an era that gave us initiative and referendum and recall, the political primaries, a kind of a democratic reform, direct election of senators. This was an era that was in which a lot of social energy was spent sort of resisting forces of corruption, corporate corruption, city bosses. State legislatures were seen as somewhat corrupt in the way they picked senators, often taking bribes and the like. So direct election of senators was a kind of clean government reform. It turns out that in order to run clean elections, that requires a lot of money too, campaign contributions, but maybe that money is spread around in ad campaigns directed at the populace rather than slipped into the pockets of state legislators. But direct election of senators was a kind of reform. And women's suffrage, of course. Prohibition was also seen as a reform of sorts. The saloons in big cities were seen as particularly corrupt places. There's a feminist angle to the whole thing. Many women felt that men, especially working men, were getting their wages on Friday afternoon, going to the saloon, drinking down their wages rather than bringing the money home to their wives and kids. And instead, because they had been drinking too much at the saloon, they would come home and beat up their wives and kids. That was a stereotype or an image that fueled the Prohibition movement, and it was a movement strongly supported by women. Remember, maybe from the history books, a famous organization you might have heard of, the Women Christian Temperance Union. And indeed, one of the major forces that lobbied against women's suffrage was the liquor lobby, because they feared that women's suffrage would actually lead to prohibition, lead to dry laws. And indeed, the 18th Amendment and the 19th Amendment are coming from the same era. Prohibition also had a national security angle. There was a need for grain during World War I, and people said, well, grain is being diverted to make beer and other things. So I did want to just briefly mention Prohibition, since I gave it short shrift last time. It's the one amendment, really, of all of them that arguably restricts liberty and equality. And interestingly, it's the one that doesn't take. Shortly after Prohibition is passed in the 19-teens, it's repealed in the early 1930s. So, and that's the 21st Amendment. And that's one of the reasons I didn't spend so much time on it, because the 21st, in effect, cancels out the 18th. But one interesting question is, how is it, from a process point of view, that an amendment could be passed? Remember, it requires 2/3 of the House, 2/3 of the Senate, 3/4 of the states, and yet so quickly thereafter you get 2/3, 2/3, 3/4 for the exact opposite position. How could that swing happen so soon? And one factor, I think, is that this was an era, the early 20th century, of democratic experimentation. The progressives believed in progress. They believed in trying things, but also learning from the data. And many people considered Prohibition a failed experiment. It was designed to stamp out the corruption of the saloon. It didn't do that at all. It just drove liquor underground, speakeasies, and a lot of organized crime. By the time of the Great Depression, a lot of people just wanted and perhaps needed a drink from time to time. And if you repealed Prohibition and brought this industry back into the daylight, you could tax it, and that would be a source of government revenue, a sorely needed revenue. So some people who supported Prohibition in the 19-teens, some politicians actually changed their minds. So you can look at the votes, and you can see some people who voted both for Prohibition and its repeal. But another factor is that Prohibition emerged from a somewhat malapportioned system. Cities tended to be wet, pro-liquor. Counties tended to be dry, anti-liquor, prohibitionist. And in the early 20th century, lots of state legislatures were malapportioned. Many House districts were malapportioned. And so in this malapportionment, the counties counted for, the rural counties counted for more than their fair share. The cities got short shrift. They weren't really proportionally represented. The urban areas, which were wet, more immigrant, more pro-liquor. And so the process that generated the 18th Amendment was one that kind of overweighted rural areas in the ratification process, and even in the House of Representatives. By the time of the 21st Amendment, however, Congress, for the first and only time, said, we want this amendment to be ratified not by state legislatures, but by specially elected conventions of the citizenry. And those specially elected conventions were, in effect, in many places, adopted one person, one vote statewide. So there wasn't the kind of malapportionment. So cities played a bigger role in that process. So with both direct election of senators and the 21st Amendment, we see an anticipation of the one person, one vote idea. Remember, when senators are picked by state legislatures and state legislatures are malapportioned, then the Senate is basically a feature of that malapportioned system. But with the 17th Amendment, direct election of senators, you count all the voters in the state equally, one person, one vote, so the Senate itself is a one person, one vote idea, and so too the process that generated the 21st Amendment involved one person, one vote. It's also possible that ordinary people are more willing to just sort of vote openly for liquor, whereas some politicians, state legislators, so in the convention, basically they're not ordinary politicians there. It's kind of like a referendum of sorts, and people vote their preferences. They want to drink. But politicians and state legislatures, even though they may occasionally have a drink or two themselves on the sly, they might have hesitated to vote for liquor, to be seen as soft on morality or something like that. So there's sometimes a possibility that ordinary voters might have sort of different tendencies than the professional politicians. Okay, so that was the 18th and the 21st. But now let's carry the story forward in time. Recall that virtually all the amendments that we've had have come in generational spurts or clusters. In the founding era, the first 12, beginning shortly after the Constitution is ratified and ending in Thomas Jefferson's first administration, the 12th Amendment. 12 amendments, 10 in the Bill of Rights, an 11th limiting the judiciary, and a 12th modifying the rules of the Electoral College. That's the founding generation's amendments. And then you have the Civil War Reconstruction generation's amendments, 13, 14, 15. Then you have this spurt of amendments in the 19-teens carrying forward to the repeal of Prohibition in the early 1930s. And the final set of amendments were all ratified in a generational, a later generational spurt, pretty much. The next spurt is really going to be 1960s. But there's one standalone amendment, kind of that's worth mentioning. And then the final amendment is a little tricky, so I'll tell you about that tomorrow in the next lecture. But the two-term amendment, the 22nd Amendment, kind of stands alone chronologically. It's ratified in 1951, so it's almost 20 years after the lame duck amendment and the repeal of Prohibition, which is early on in Franklin Roosevelt's administration. So 20 years basically after the last set of amendments and 10 years before the next cluster, this two-term amendment kind of just stands out there on its own chronologically. And let's talk about that amendment. Remember that the original Constitution on paper allows for a president to be perpetually re-elected. Every 4 years he has to come before the electorate, and 4 years means absolutely 4 years. Come hell or high water, we hold presidential elections in the middle of civil wars and world wars and Great Depressions. That's not true in an English parliamentary system where the elections can sometimes be pushed back. And in fact, in World War II, basically Parliament postponed elections. There basically was no election at all, a regular parliamentary election in England between 1935 and 1945. But in America, we held elections on schedule every 4 years for the presidency. Lincoln, in the middle of the Civil War, submits to the voters' judgment. And but under the founders' written constitution, presidents are perpetually re-eligible. But as we talked about before, George Washington set all sorts of important precedents, and one of the most important is that he stepped down after 2 terms. He would have been re-elected had he stood for a 3rd term. He was unanimously picked the first time around in 1789. He was unanimously re-elected in 1792. He would have been unanimously or virtually unanimously re-elected, but he stepped down. And he didn't say a lot about it, but later Americans came to understand that Washington was sending a signal that the republic needs to be bigger than any one person, and that he was kind of in part sending that message that other people are perfectly capable of carrying the torch. And indeed, when Thomas Jefferson wins re-election, he steps down after his 2nd term and says explicitly, I don't think we should have, in effect, a lifetime presidency. John Adams, of course, runs for re-election and loses, so it's not really an issue for him. But when Thomas Jefferson wins his 2nd term, at the end of that, he declines to run again. And remember, in the states, governors that were governorships that had no term limits to them, the governors were almost always re-elected, basically, until they died or were close to death. John Hancock in Massachusetts, George Clinton in New York, Trumbull in Connecticut, also in New Jersey. Governors who could run for re-election ran again and again and again and were almost always elected. But Jefferson didn't like that model, so he said, like Washington, I think I should step down after 2 terms. After Jefferson, James Madison did the same thing. James Monroe did the same thing. John Quincy Adams runs for re-election and loses. Andrew Jackson, after 2 terms, steps down. Thus, a tradition emerges. It's not in the text, but it's a tradition of 2 terms. Now, that tradition isn't inviolable. The next president who gets reelected, Abraham Lincoln, is assassinated, so we never know whether he would have chosen to follow that example or not. McKinley also is assassinated in his 2nd term, so we don't know. We do know that there were some presidents who did dream, at least, of 3rd terms. It's a little cheeky, though, given the tradition. If you're basically saying, well, I'm greater than General Jackson and General Washington and Thomas Jefferson and James Madison because, I'm going to seek a 3rd term even though they didn't. But Ulysses Grant, after 2 terms, steps down following the Washington precedent. And Grant is in a lot of ways like George Washington, this general above political party. He steps down, but then 4 years later, he gets the itch and he kind of runs again. And maybe, you see, the tradition is not so clear. Is it that no 3rd term or no 3rd consecutive term? There's an ambiguity in this unwritten tradition. So Grant steps down and but runs in the Republican process, the Republican convention. 4 years later, doesn't get it. Grover Cleveland, he wins. Then he loses his bid for re-election. Then he runs again and wins, so he now has 2 terms. And he dreams of a 3rd term. It wouldn't be a 3rd consecutive term. It would be a 3rd total term, but only a 2nd consecutive term. But the Democratic Party isn't interested in having him. There's another issue unresolved in the tradition. How do you count partial terms? Teddy Roosevelt basically has 3 years as president when McKinley dies. Then he wins in his own right. Can he run for a 2nd term in his own right? 2 full terms as president, plus early 3s. Well, he decides not to. But then 4 years later, and Taft becomes president, but 4 years later, Teddy Roosevelt gets the itch again, and he runs and he says, yeah, when I said I didn't want a third term, I meant a third consecutive term. If I said I didn't want a third cup of coffee, no one would think that I was forever giving up the beverage. So he runs, loses. Woodrow Wilson is dreaming of a third term even after his stroke. So the tradition is ambiguous in certain respects, how to think about third terms, how to think about non-consecutive terms. And of course, famously, Franklin Roosevelt serves not 2, not 3, but he actually serves into his 4th term. He dies early in his 4th term, but he runs for a 3rd term and gets reelected for that 3rd term, and runs for a 4th term and gets reelected. And in the wake of that, the 2-term amendment, the 22nd Amendment, emerges. And it's kind of a retrospective rebuke, to some extent, of the Roosevelt precedent. It's saying, never again should one person make himself so indispensable. And remember, this is emerging in a world where there's anxiety about other strong leaders around the world, Stalin and Hitler and Mussolini. And so people say, American democracy should never be organized around one indispensable man, the fearless leader, the big brother. So the critique is that we shouldn't have, basically, presidencies for life. The folks on the other side say, well, it's up to the voters to decide. We have elections, and if you don't want the fellow, vote against him. And the believer in presidential term limits say, no, but a president, as a practical matter, can entrench himself in all sorts of ways and make himself an indispensable leader. And so in the name of democracy, we're going to limit presidential terms. And interestingly, once the federal government does that, a bunch of states follow suit for governorships. Many states, though, prohibit just more than 2 consecutive terms, but they allow non-consecutive 3rd and even 4th terms. But once again, we see a very interesting interplay between state constitutions and the federal constitution. The Constitution was modeled on state constitutions to some extent. It created, and in turn was copied by state constitutions. Constitution, in particular the presidency, created a very strong executive branch, and then states started to reconfigure at the founding their governorships to look more like presidents. 4-year terms, veto pens, pardon pens became much more common at the state gubernatorial level after Article 2 had put forth that model. And so, too, after the Constitution, the federal Constitution is amended to add term limits for the presidency. A bunch of state constitutions add term limits for governorships. Now, these term limits create very interesting incentives, and I'm going to close, actually, with this lecture with a conversation about sort of what happens when you term limit the executive. Well, one thing maybe you see is that we've seen is actually presidents in their 2nd terms are weakened. They're lame ducks from day one, and so their enemies can come out and attack them, knowing that they're not going to even be able to threaten to run on a 3rd term and vanquish their foes. And so we've seen in 2nd term presidencies recently Richard Nixon resigning in disgrace under the threat of impeachment, Bill Clinton actually being impeached, not convicted, but impeached. Ronald Reagan having Iran being wounded politically in Iran-Contra in his 2nd term. George W. Bush kind of limping along a bit in his 2nd term. We'll see how the Obama 2nd term runs. But one feature structurally is that the 2-term amendment makes a president a lame duck at the beginning of the 2nd term. At the state level, sometimes term-limited governors have run their wives. In effect, vote for Lurleen Wallace for George Wallace's additional term, and Ma Ferguson in Texas, and so that's been a strategy that sometimes has occurred at the state level. But the final thing I want to talk about at the federal level is how this weakening of the presidency through the 2-term amendment has actually empowered vice presidents. If a president can't run for a third term on his own, but he can run, in effect, by proxy by picking his wingman, his vice president, to be his third term. And before the two-term amendment, you didn't see vice presidents really weren't very significant. They were significant at the founding, because remember, at the founding, at the very, very beginning, the vice president is the guy who comes in second for the presidency. So John Adams is someone substantial. So was Thomas Jefferson. They ran for the presidency, but came in second. But remember, the 12th Amendment lets you vote separately for president and vice president. It creates a ticket system, and after the 12th Amendment, vice presidents basically are really not typically very important political figures. There are one or two who are significant, but generally not. But after the 22nd Amendment, vice presidents kind of begin to come into their own. Between the 12th Amendment and the 22nd Amendment, the two-term amendment, only about 15% of vice presidents ever won their party nomination for the presidency itself. They weren't sort of major figures. But since the two-term amendment, more than half of them vice presidents have actually won the party nomination for presidency later on. At the end of the 20th century, I think 5 resigning presidents all sort of watched their wingman, their vice president, sort of run for president in his own right. So Eisenhower watched Nixon run, and Johnson watched Humphrey run for president, his vice president, and Richard Nixon, who had resigned already, watched Gerald Ford run, and Reagan watched George H.W. Bush run, and Clinton watched Gore run and win, again, the party nomination. So one of the important stories of the 22nd Amendment has been how it's actually strengthened the political tag team between president and vice president. Vice presidents become president's wingmen, and the way, in effect, in the modern era, you win a third term, you become like Franklin Roosevelt, is not by running and winning in your own right, but having your hand-picked successor run. George H.W. Bush, that was Reagan's third term on this interpretation. Now, two of the themes that we've talked about today, one person, one vote, and the tag team between president and vice president are going to be themes we're also going to see in the last round of amendments from the 1960s, and that's going to be the story I'm going to tell you in the next lecture. So hope to see you. Welcome back. We're up to the set of amendments in the 1960s, the most recent really set of amendments, and the 23rd and 24th Amendments fit very nicely into our general story. The 23rd Amendment brings the District of Columbia into the Electoral College system. Remember, the Electoral College system is one in which different states are assigned electoral votes based on their population, originally connected to the 3/5 clause, but with the end of slavery, the 3/5 clause has dropped away. But the Electoral College system is one in which states are basically the fundamental units for determining presidential elections. And the 23rd Amendment says, well, we're going to allow D.C. to be part of that Electoral College system. It's not going to be a state for the House of Representatives. It's not going to be a state for the Senate, but we are going to allow it to have a few electoral votes, as if it were a state in effect. And the 24th Amendment is going to end, prohibits poll taxes in states being used to prevent people from voting in federal elections, for example, for the Senate, for the House of Representatives, for the presidency. The Supreme Court is going to take, in the same era, the 1960s, some of the deep animating principles underlying that 24th Amendment and actually say, gee, not only should there be no poll taxes for federal elections, there should be no poll tax disfranchisement for state elections either. So how, you might ask, does that fit into the general story thus far? Remember, the general story thus far has been a story of democracy, national security, and slavery/race. So let's take the District of Columbia. Here's one thing you need to understand about D.C. There's a very substantial proportion of non-whites who live in D.C., of African Americans. That's true today. It has been true for the last 150 years at least. Remember, early on, the District of, before Abraham Lincoln's presidency, the District of Columbia is actually a slaveholding jurisdiction. It's part of, it's on the border between Virginia and Maryland, both of which were slave states when the Civil War broke out. So there are a lot of black people who live in D.C., and when you bring D.C. into the electoral college system, you are advancing democracy and actually the cause of racial justice. And democracy is itself a part of the process. It's not just the result of DCs being brought in, but it's part of the process. We've been talking about party competition, presidential parties. Both parties support, the Republicans and the Democrats, support this move to bring D.C. into the Electoral College fold. And that's because in the middle of the 20th century, both the Republican and the Democrat Party are vying for the allegiance of African Americans, actually. Before FDR, blacks very reliably vote Republican, Party Lincoln, before 1932. After 1972, after sort of the African Americans overwhelmingly vote Democrat. But between 1932 and 1972, so the black vote is kind of up for grabs. Both political parties are trying to get it. Blacks are a swing democratic, a swing demographic, constituency, maybe like Hispanics are at the beginning of the 21st century. So FDR has won a bunch of black votes, and Truman has desegregated the armed forces, and when he runs for election in his own right, it's the black vote that's the margin of victory. Had Thomas Dewey, who ran against him, actually won the African-American vote, Dewey would indeed have beaten Truman and won the presidential election. Eisenhower was trying to win back the black vote, and both Nixon and Kennedy in 1960 are vying for the black vote. And D.C. is kind of part of that whole conversation about African Americans more generally. And the 23rd Amendment is proposed under Ike and ratified under JFK, and I think it's a nice symbol of some of these issues. Now, how does national security factor into this? So we've talked about democracy and we've talked about race. National security figures in part because there's not just a domestic audience when it comes to race relations in America, but an international audience. We're in the middle of a Cold War, and the Soviet Union is having a propaganda field day in Africa and Asia. That's the battlefield of the Cold War. We're trying to win a Cold War, and we're trying to win for the hearts and minds of brown skin and black skin and yellow skin people in Africa and Asia and South America. And the Soviet Union is saying, oh, the United States doesn't practice what it preaches. It has segregation. It has discrimination. Look, its national capital has a bunch of black people, and they don't even get to vote fairly in presidential elections. And the 23rd Amendment is, trying to actually say to the rest of the world, no, actually, we are trying to solve our racial problems. Now, you might say, well, D.C. was never in the Electoral College system. It's not about race. It's just the Constitution has different rules for territories. And that made a certain amount of sense at the founding. D.C. wasn't part of the Electoral College system, but neither were the territories. And there were a lot of territories, and a lot of people lived in the territories. But as the territories gradually became states, admitted on equal footing, remember the story that we told thus far, the new states, the territories, the West wasn't being treated as a permanent Western colony of the East Coast. As those territories became states, it seemed increasingly anomalous that D.C. was left behind. So D.C., was left out of the system even as the territories became states. And at the time that anomaly became increasingly clear, when the West, the frontier ended, and Wyoming and Arizona and the other western states are finally coming in, D.C. status seemed increasingly anomalous, and people started to notice a lot of black people are living there now, and so D.C. brought into the fold is part of a larger geostrategic story. Remember, at the same time that this is happening, Hawaii is becoming a state, the 50th state, Hawaii 5-0. Alaska is becoming the 49th state, projecting beyond the continental lower 48, the contiguous lower 48. And there's a national security story there. We want to project power after World War II into the Pacific. Pearl Harbor, was a scene of military disaster, but we have to project power into the Pacific Rim toward Japan. Alaska borders on Siberia, the Soviet Union. We want listening posts close to the Soviet Union. Remember also, Alaska has a pretty substantial proportion of non-whites, Aleuts, and Native Americans. Hawaii has a very large percentage of non-whites. So Alaska and Hawaii and D.C. are all part of the story of the Cold War, of race, but also of increasing democracy. This is also the era, the 1960s, that's going to give us an Immigration Reform Act that's going to make it possible for people from Africa and Asia and South America increasingly to come to the United States. And this is part of a Cold War idea. We want to be open to the talent of all the rest of the world. And D.C. is part of that larger story. Now, D.C. is still not quite given full treatment. It's not in the House of Representatives. It's not doesn't have 2 senators. It's not admitted as a state. And I'm not predicting necessarily that will happen soon, because the window of special opportunity, I think, closed to some extent in the middle of the 20th century. Because remember what I said, blacks are politically in play. They're a swing constituency between 1932 and 1972, and they make a lot of progress, in part because both political parties are vying for them. Much as earlier political parties didn't want to offend women, and so at a certain point both basically said, oh, we're for women's suffrage. Well, now, when blacks are in play, both parties are wooing them. But after 1972, blacks are quite reliably members of the Democratic coalition, and not at all clear that Republicans would support D.C. statehood, for example, because that's going to mean 2 more Democrat senators, another one, possibly 2 members of the House of Representatives who would be Democrats. So not at all clear that Republicans would support more stuff for D.C. today, constitutional or tweaks or full statehood. Not at all clear that today's Republican Party would support that, but the Republican Party of the middle 20th century, the party of Eisenhower, did very much support that. And remember, it's an Eisenhower appointee, Earl Warren, who hands down Brown versus Board of Education. And in fact, Eisenhower's Justice Department supports Brown versus Board of Education. And so in this period, in the middle of the 20th century, both Republicans and Democrats are actually supporting civil rights and voting rights. And that takes us very naturally to the next amendment, which is about voting rights. And it's an amendment that says states shouldn't have poll taxes that prevent people, because they can't pay those taxes, from voting in federal elections. Remember, under the original Constitution, you get to vote for the House of Representatives if you can vote for your state legislature. So state law sort of defines in the first instance who's eligible to vote, even for Congress. Remember, states regulate how the presidential electors are to be selected. It's a state-defined electorate that picks senators under the 17th Amendment, the Direct Election Amendment. And 24th Amendment said, well, for federal elections, the inability or the unwillingness to pay a poll tax should never be a basis for disenfranchisement. You should be allowed to vote whether you pay a tax or not. This is a grand egalitarian Republican idea, or small r Republican, small d Democrat. And both the Republican and the Democrat Party support this amendment. And the Supreme Court, a Supreme Court that's led by a Republican Chief Justice but has a majority of New Deal Democrat appointees on it, is going to go one step further and say not only should there be no poll tax disenfranchisement for federal elections, we shouldn't have it for state elections either. A Republican government, small r, should be a government of the people, res publica, the people's thing. Not the properties thing. It's not about money or taxes. It's about the people deciding whom they want to represent them. And so these amendments, the 23rd and the 24th, are powerful extensions of this democracy idea that we saw at the founding, that carried forward through the Reconstruction, that was further elaborated by, for example, the direct election of senators in the progressive era. So that general story continues with these amendments. And at the very same time that these amendments are being proposed, Republicans and Democrats in the middle of the 1960s are going to get together and pass an epic Voting Rights Act that further reinforces the idea of federal protection of voting rights, implementing the grand themes of the 14th Amendment and the 15th Amendment that had to some extent laid dormant. Because here's one thing, the dirty little secret that I didn't mention about poll taxes. Poll taxes are basically used in the former Confederacy when in the 1960s. Those are the only states that really have poll tax disenfranchisement, and they probably disenfranchise blacks disproportionately. And this amendment and the accompanying Supreme Court cases extending this amendment understood all of that. So definitely a story of race. And the Voting Rights Act of 1965, following on the heels of the Civil Rights Act of 1964, act supported by Republicans as well as Democrats, Party of Lincoln Republicans as well as Democrats that are trying to repudiate, new Democrats, the legacy of the old Democratic Party, which is about slavery and segregation. This coalition that gives you the Civil Rights Act of 64, the Voting Rights Act of 65, is doing so, again, in part with attention to a world stage, trying to persuade people of goodwill in Africa and Asia and South America that America actually is an open society that really does practice what it preaches, which is, after the 13th, 14th, and 15th Amendments, equality, which is, after the direct election of senators, an idea of equal voting and one person, one vote. And indeed, in this era, the Supreme Court is going to give us some landmark cases, which we're going to talk about much later in this lecture series, on the idea of one person, one vote. 25th Amendment. It's also about war, in particular a Cold War. After President Kennedy's assassination, Americans realized with sort of blinding clarity that the rules of presidential succession need to be modified. God forbid, had President Kennedy been in a coma, lingered for a long period of time, maybe in a persistent vegetative stage, something like that, it was not entirely clear how a vice president could pronounce a president sort of disabled to discharge the office and put himself forward. And in a Cold War with nuclear weaponry, minutes can matter. I mean, there always has to be someone ready to take charge, and the original Constitution didn't have a very elaborate system specifying who should declare a president disabled. It also said that if a president did die and the vice president came forward, the Constitution didn't provide a mechanism, a backup for creating a new vice presidency. So for 40 years of American history, before the 25th Amendment, America basically didn't have a vice presidency because the vice president had died and there was no way of filling that vacancy, or the vice president had resigned and there's no way of filling that vacancy, or a president had died and or resigned, become disabled, and the vice president had moved up into the presidency. Again, there's no way to fill the vacancy. The 25th Amendment plugs some of those gaps, and it's in part motivated by Cold War reality that minutes can count, even seconds can count, and there has to be a person capable of making decisive decisions at every moment. And the 25th Amendment says, look, if the president dies, the vice president actually officially becomes president. It made that clear. There was maybe an ambiguity about that. That had been our tradition, but the 25th Amendment makes that very clear. If a vice president becomes president because the president has died or resigned, that incoming president can fill the vice presidential vacancy, can nominate someone basically to be the new vice president, subject to special congressional confirmation process. And if a sitting president is going to undergo some planned surgery or something like that, know he's going to be out of action for a while, know he's going to be temporarily disabled, he can provide, the 25th Amendment provides a mechanism by which he can basically officially designate the vice president as the person in charge, and then when he recovers, take that back very easily, allowing seamless handoffs of power back and forth between president and vice president. It's a constitutionalization of the tag team idea, the ticket idea, that the president and vice president are going to work very closely together. Presidents are going to be picking their vice presidents under the 25th Amendment, as Richard Nixon will handpick Gerald Ford when the vice presidency becomes vacant, when Spiro Agnew resigns. And Ford, in turn, will pick Rockefeller when Gerald Ford becomes president. This is a kind of textualization of the idea that in the political parties, what's emerging is a tradition that the presidential nominee handpicks his running mate. That wasn't so clear for much of American history, but it's more clear today in political party practice. And in the text, there's this close working relationship between presidents and vice presidents. Presidents basically pick their running mates. Their running mates often succeed them. They're their wingman, and they can hand off power back and forth in cases of anticipated disabilities, let's say a planned surgery or something like that. One of the big areas of vulnerability, if all of this is true, we're going to talk in later lectures about whether the other rules of presidential succession, the statutory rules, make sense. Does it make sense if you really want presidents to hand over things very easily to the next in charge? Does it make sense that after the vice president, the next person in the statute is the Speaker of the House, who might be a member of the other party, rather than, say, the Secretary of State, who'd be part of the same presidential administration? In other words, does it make sense if something happens to both Ronald Reagan and George Herbert Walker Bush at the same time? Would it make sense to have, if something happened to these two Republicans, have Democrat Tip O'Neill take over rather than a Republican Secretary of State? If something happened to Obama and Biden, would it make sense for Boehner to take over rather than, say, John Kerry? That's something we're going to come back to in later lectures. The 26th Amendment, which is also a product, it seems to me, of our great themes of race, democracy, and national security. The 26th Amendment says that 18-year-olds get to vote. And they have a constitutional right to vote, not to be discriminated on grounds of youth. And a couple of things. One, young adults are actually in America in recent history have been more likely demographically to be non-white. So this is actually an amendment that brings more non-whites into the process proportionally, just as getting rid of poll taxes has a racial effect that's racially inclusionary. It's an expansion of democracy. Both political parties actually were in favor of it. So both parties were sort of competing for the young American vote in the way that they earlier competed for the woman's vote, and were competing for the black vote in the middle of the 20th century, are now competing for the Hispanic vote, swing constituencies. And what's the larger story? Obviously Vietnam. If 18-year-olds are old enough to fight and die in Vietnam, to be drafted even against their will to fight, then they're old enough to vote on whether we should be in that war in the first place. So thought Barry Goldwater, Mr. Republican on the right, and Richard Nixon, a Republican president, and Democrats on the left. It's a story that we've seen over and over again, connections between national security and democracy. If you're old enough to fight, you're old enough to vote. Just as at the founding, if unproperty people could fight in the American Revolution, and they did, as loyal militiamen and sailors at places like Lexington and Concord and Bunkers Hill and Washington's army and on the high seas. If unproperty people were, we were willing to take them and have them fight for the patriot cause, they should be allowed to participate and vote in this new system. And after the Civil War, if black men could risk their lives and limbs for the Union, they should be allowed to vote. And that's the 15th Amendment, and we saw that dramatic picture. If women are really part of the economic support structure for our wars, as they were in World War I, they should be allowed to be equal voters. Young adults, if they are fighting and dying in Vietnam, risking their lives and limbs, they should be allowed to vote on that thing, on that war and everything else. So the 27th Amendment, I'm not going to say a lot about. It was proposed actually in the founding era, and it gets ratified 200 years later. It's an amendment that says that congressional pay changes, especially congressional pay increases, can't go into effect until there's been an intervening election. So it's a pro-democracy amendment, basically saying certain things shouldn't happen until the people weigh in. It's a smallish amendment, a kind of tweak. It's kind of interesting just because it was originally proposed by James Madison, passed the House by 2/3, the Senate by 2/3. Not enough states ratified, but eventually, 200 years later, enough states did to put it over the top. The story is told in more detail in the book. What I want to end my lecture today with, before I talk about this picture, remember we're always talking about pictures, is the 28th Amendment. You say, what? 28th Amendment? What 28th Amendment? Exactly. Our Constitution, the end of the Constitution, in my view, isn't the 27th Amendment. It's the vast creative white space after the 27th Amendment. Remember, we keep adding amendments in textual order. The Constitution always has a kind of unfinished look to it. We don't word process it and stick and rewrite the thing start to finish so it looks complete. It always looks kind of incomplete. Why 27 rather than 28 or 29 or 37? So the most interesting question is, what's the next amendment going to look like? And the amendment after that, that is a question for our generation and our posterity. It's a question, my fellow citizens, for you to ponder. What amendment would fit the story that we've been telling, that would be a suitable next chapter to this epic unfolding American saga? And with that, I think we come to kind of where the written Constitution ends and the unwritten begins. One idea of an unwritten Constitution is the Constitution still to be written, the amendments of the future. And the 28th Amendment is, I think, one way to really think about what is this story thus far, what has been done, what remains to be done that would be fitting as part of this extraordinarily intergenerational project. Because remember, the Constitution is not just about the founding. It's about the amendments as well, and those amendments are on, that possibility still continues. Earlier generations made amends for the sins of the fathers, their pro-slavery aspects, for example, the original Constitution, and this generation can do the same. It's up to us. We will talk about that a lot over the second half of the course when we talk actually in rather great detail about the unwritten Constitution. But for now, I just want to close this lecture with this picture. This is a picture of the March on Washington in 1963. And note how it's a continuation, really, of the story we've told thus far. We began Chapter 1 with the preamble, we the people, ordinary people getting to decide how they and their posterity would be governed, getting to vote, getting to deliberate, discuss, participate. Extraordinary. And then we had images of freedom of speech and debate in the early Congresses. Henry Clay speaking with Daniel Webster and John C. Calhoun and the gallery listening. And then we talked about how in the Civil War, black men risked their lives and limbs for the Union, and in the process won the full rights of political participation, not just freedom with the 13th Amendment, but civil equality in the 14th and voting rights in the 15th. And then we saw in the last chapter women taking to the streets and demanding full and equal justice, demanding suffrage rights. And the story continues here with another group of Americans taking to the streets to demand freedom, and an end to bias, equal rights now, integrated schools now, an end to police brutality now. Some of the demands, you see, they're almost ripped from the headlines. Some of the same issues are the issues of 2013. I'm actually giving this lecture at a time of the 50th anniversary, really, of the March on Washington. This was 1963, 50 years ago. And that story, ordinary people taking to the streets, appealing to their fellow citizens. This is where Martin King gives that famous I Have a Dream speech. This is the day which he does that. And both Republicans and Democrats are marching, blacks and whites, men and women, Jews and Gentiles, gays and straights, not as many openly gay, but some of the people actually in charge of this march were, in fact, gay, we now know. And they spoke. Americans listened. The result of this taking to the streets will be epic constitutional achievements, some statutory, some in the case law, like the Civil Rights Act of 64, the Voting Rights Act of 1965, landmark Warren Court opinions on just some of these issues. We will talk a lot more about some of that in the second half of this course as we explore America's unwritten Constitution. So I hope to see you for that. Stay tuned.